We continue getting feedback from the public, but I want our communicators to develop more and frequent and focused messages, especially through radio to the people of Kenya, and in Kiswahili, and even in mother tongue, to the people. We must, I believe, our communication with Wanjiku has not been effective, and that is the only way. There's no magic word, but it can be done. I will do my part.
Thank you very much, my Lord. Honourable Madam Chair, that's all from my side. Thank you very much.
Thank you. Thank you very much, Honourable AG. I will now request Commissioner Gishohi to please ask your questions, Commissioner.
Thank you, Chair. Judge, good afternoon.
Yes, good afternoon.
Yes, before we go down to the lines that I'm assigned to, I would like from you, you have spoken very passionately about the institution. Yes, you can take the water first.
Sorry, I think.
Yes, just open it through the chair.
Thank you.
Good. You have given us a long journey, your experience, your career, all the way from the university down to the Kingdom of Swaziland, East African Community, FKE, and also here. I want you to share one lesson, just one lesson, through that journey that you have learned that prepares you for the position of the chairperson of this commission. Just one lesson that you have learned that prepares you for this position of chair of the commission. What lesson have you learned? One. But I want you to focus as the chair of the commission.
I think the biggest attribute of a good chairperson is respect. Respect of the members of the committees they chair. Two, to be prepared every time when you sit as a chair of the meeting.
Okay.
So that you appear all the time to be in control and knowing what you are doing. And three, you must develop friendships. All the time, with the people you work with.
Okay.
Yeah.
Let's take that. Then I would like you also to, I'm sure when you are preparing for this interview, you had a look at the documents that we have for all the issues, and your position as a judge also. The key areas of concern, I'm sure you talked about the disciplinary part, that you are not very satisfied with the process of discipline in the commission. Apart from that, which other areas would you address as you come in as a chair of the commission? As it relates to the commission, which two other areas would be of concern to you and you'd like to address them? Two areas.
I would really, thank you first of all. I would really want to help and work with the commission to enhance their ability to mobilize funds for education of judiciary staff and judges and the magistrates, because I recognize that is a core mandate of this commission, and I've already spoken so passionately about it. So I would really want to engage and work with the commission so that we are very focused in, first of all, in developing, helping JTI to develop programs, to mobilize funds, and to conduct training needs analysis, so that we just don't do training for the sake of it.
Very good. Let's take the case of staff. Efficiency, productivity is very, very key for public service. Efficiency, productivity, service delivery. What strategies you do put in place? 2 strategies that you put in place to ensure that we increase our efficiency, productivity, particularly on part of staff. 2 strategies that you'll be able to put in place to increase the efficiency, productivity on the part of staff.
First of all, I must recognize the strategies in place already. There are a lot of work done because I have looked at what, first for the directorate, I don't remember the PMMU, the measurement and accountability department has the frameworks which are in place for ensuring that, measurement of individual productivity, group unit productivity. I think for me it will be a matter of really upscaling and continuously updating and enhancing use of technology in whatever they are doing, so that we have accurate data, friendly methods of making sure we have a true reflection of work being done. 2, the reward and sanction mechanisms also need to be very transparent. As I already touched on that. I would really focus on that because I know recognition is, I have a HR background.
Okay.
Recognition works much more than even the salary in ensuring productivity of employees.
The Honorable Attorney General did allude to this, and I want to refer you back to it. In terms of the surface you have looked at and the statistics that you have, in the last 10 years, the population within judiciary, in terms of staff, has increased by almost 65% in terms of the population, almost 65%.
So pardon me, what has increased?
The staff.
Okay.
In terms of all the cadres, including judges, magistrates, and the staff. And also, to some extent, the budget that we had in 2010 or 2011 has also increased. Not so much, but it is reasonable. And you read about the surface satisfaction, but the Kenyans still are very much concerned that our service is below expectations. That's the reality on the ground. That the service that we give the Kenyans is still below expectations. I want from you, Judge, particularly coming from this Court of Employment, Labor Relations, and you are the chairperson of the Commission, to be very, very clear as you share the Commission, what we need to do, apart from that survey. What have we missed? What do we need to do different to ensure that our clients, the public, get some reasonable satisfaction in terms of our work?
That feedback, Commissioner, we get as a judiciary on the levels of satisfaction, the output, our work, especially the manner we are able to conclude cases from filing to judgment. And in other areas where we are giving service to the people, the demands we're getting from the public are not, there's the good and the bad of it. Remember, under JSC, the Mutunga program opened up the judiciary on levels of transparency and accountability never experienced before in this country. And I believe the judiciary, if well judged, is the most open organ of government. That is double-edged because the more you open up and you are clearly delivering much more than you've done before.
So you
The level of expectation grows with that, and rightly so. And all we need to do, as I conclude, is that we need to continue doing the good things we are doing. If you expect one day to be told, finally you have arrived, it will not happen.
Okay. So if somebody appears in your court tomorrow morning on a new issue, which is the earliest date can you give that person in terms of maybe his case to come? How soon?
Right now, in my specific court now at Milimani, remember I've just been come from Kisumu to Milimani, and first of all, we are not giving dates for matters 2018, 2019, 2020. You cannot get a date. That is how bad it is. We are only giving dates for 2014, 2015, and 2016 matters.
So what does that tell you?
I remember under the SJT, we cleared almost all the 2014 cases. And we had embarked on another rapid initiative to clear the 2015, which I think will be my focus. Now, another rapid initiative through different methods to now focus on 2015, 2016 cases. This is the same in Kisumu, where I was for 3 years. We have 2014, 20 now. I think 2014 is almost gone. It is gone. 2015 almost gone. We have 2016, 2017, 2018 matters.
Okay.
Which there they have dates because there is no restriction. In Nairobi, there were notices from the principal judge that you cannot get dates for these years. You have to wait because we are dealing with these other cases.
Okay.
So it's that bad.
6 years old there?
Yes.
You're talking about efficiency. Let's move on to something else. I want to look at financial. You talked about financial and funding. Kenyans believe under the Constitution, we should be able to fund the judiciary from our taxes to some extent. What as a chairperson of the Commission, accountability for the funds that you are given is very crucial. What kind of mechanism would you put in place? And here I want you to be aware of the Constitution, the various statutes that you have that govern our financial structures and governance. I want to hear from you as a chairperson of the Commission. That top, you are the head of the Commission, the accountability mechanism that you put in place to ensure that the funds that you get are properly accounted for and used. Accountability mechanism. 2 or 3. As a chair.
First of all, the expenditure of funds in whatever area in government.
No, Judge. I want us to focus. You are the judiciary, the chairperson of the Commission.
Yes.
My question is very specific.
Yes.
Accountability mechanism that you have to put as you manage, or the funds are managed. Because the boss stops at you. As those funds are being managed, what mechanism will you put? Maybe it be personnel, procurement, all those issues. I would like to hear from you at least 4 mechanisms that you can put in place to ensure that you're in charge of those funding.
The one immediate one is that once funds are received from Exchequer, I, as the head of the judiciary, knows and have received reports. I mean, I'm aware of our budget, and what the money has been allocated for. And I know the specific areas where money has been allocated for. So my first responsibility is to ensure that, first of all, money which has been allocated to us is absorbed and used. Two, to ensure that I have the tabs on how the money is being used. I expect feedback from the finance chief registrar, which I expect to have channels of feedback and reports on procurement.
Share with us those reports that you expect to get from the accounting officer. And you don't do the work of the accounting officer. Share with the commission what kind of reports that you expect to get from your accounting officer as far as the management of those funds are concerned. And I see it across the board: procurement, personnel, all the rest.
First of all, a report on procurement, what has been procured within a specific period. There must be a report to me matching what the requisitions, whatever we had planned to do with the money. There should be an audit reports also.
Audit reports
at the internal level, which must come to me to make sure I am in touch and with the manner in which expenditure is being used.
Okay.
The other one is that
are you familiar with the financial management within government, within public service? That's my question, the bottom line.
Yes, I have the frame. I know we have the Act and the framework which is in place for monitoring of use of funds and accountability, and especially the report which finally must go to Parliament on accountability.
Let's move on. Placing those funds, and I want us to remain focused to your position, to your role as the chairperson of the commission. You need to secure funds for judiciary. What role do you play in terms of making sure that judiciary, including the commission, gets adequate funds from the various arms of government, particularly the two arms of government that are responsible for the government funding process?
First of all, the Chief Justice must have a very constructive interface on issues, finance, and our requirements, even at the level of the head of state.
Interface with the head of state?
Yes.
In his capacity
as a head of the nation, as a president of this country.
Very good. Then the next interface? The next
interface is with the heads of, with the exchequer. I mean, with the CS Treasury.
CS stands for what? CS?
Cabinet Secretary.
Treasury, yes.
Treasury.
Very good.
The other interface is with the Speaker of the Senate and the Speaker of the National Assembly.
I want you to break down the Honorable Speaker's offices and share with us the organs within that legislature that are very key to make sure that we get our funds that we require.
We have two key committees, which is a committee on allocation of finances.
Appropriation committee, we call it, yes?
Yes. We have the committee dealing with judicial and legal matters.
Judicial, yes, very good.
Yes.
We have had this judiciary fund for some time, and you have been trying to make sure that the judiciary fund is actually established, realized, and getting funds in that fund. We are here to get the position as the chairperson of the commission. What steps do you take to ensure that the fund is up and running? the judiciary fund, which is in the Constitution.
The Act is in place.
Yes,
if
it's
I'm
in place.
not wrong.
It is in place.
The regulations have been developed.
They are in place.
They have not been implemented.
So what will you do to have it implemented? Two things you will do to make sure it is implemented.
Again, I believe the Office of the Attorney General has a role to play in that. The Parliament has a role to play with that, and it will be part of the agenda, the robust agenda we'll have with the heads of, with the AG's office and Parliament to ensure that fund is in place.
Okay. What will be the role of the Office of the Honorable Attorney General in that process?
First of all, Attorney General sits in Parliament. I don't know whether Attorney General has a key role in the development of whatever regulation and registration in Parliament.
Are you sure he sits in Parliament? Does he sit there?
He doesn't sit now, I think, but I think he has a key role in guiding development and implementation of regulation, including gazettement, and making sure that it is done. So we have solutions within and without there. Okay. And as the Chief Justice, I think I will seek, first of all, I want to understand the issue much more. Okay. And I would have that opportunity once.
So, Honorable Judge, and that's good enough for me. I want us now to tackle different issues altogether. And this is specific to your court, the Employment Labor Relations Court. What is the role of that court as far as economic development is concerned, Vision 2030? Does that court have any role in terms of realization of Vision 2030? That's your court, Employment Labor Relations Court. Does it have a law, and if so, which one?
Labor is a key component of, that is human resource. It's a key component of, in fact, the center of any development initiative. Without people and with proper legal frameworks and which are properly interpreted with certainty, and that is a key role of our court, to interpret the laws in place in a just and consistent manner, so that there is certainty in what investors expect is certainty of the law and outcomes before they bring their money into any particular country. I believe the Labor Court has got a key role in ensuring that jurisprudence which guides labor is well understood by potential investors, is just and fair, and that is what we should continuously make sure, so that the country attracts direct and indirect investment.
Okay. What is the turnaround of cases in the court? You know, this is very crucial because Vision 2030, when it was started, people thought it was a very far off vision. We are maybe 9 years before we come to 2030. We are going to have a measurement in terms of your court and the realization of that goal. I mean, where would you place yourself? You have spent almost of your time in those courts. Where would you place yourself? Are we anywhere getting anywhere near? As you address that, I want you to address the turnaround, particularly for disputes that between the employer and the employees that are supposed to be unlocked to ensure that we realize our goals.
Yes and no, because the turnaround period of cases in E&LRC depends on the age of the station. We remember this is a court which has been slowly unrolled. I mean, it's being stations being,
on average. Let's take on average.
So out there in specific stations, it takes months.
Months.
Kericho, Eldoret, Nyeri, it takes only months to clear cases. Go to Kisumu, Mombasa, and Nairobi, takes 3 years. So we have 7 court stations, and we have now 11 substations, where we are hopefully we will become Chief Justice. They will soon become fully French courts. In those stations, they don't even have enough work. In Kisumu, Mombasa, Nairobi, I will have a strategy. And I've just said that we are dealing with 2016, 2017, 2018 cases. If we are focused in clearing that backlog, obviously the new cases are ignored. And so the case clearance measure is very poor in those stations where we are focused on the old cases, because justice dictates that we deal with the older cases first, and therefore we ignore the new ones. And so we appear to be stagnating, because it is good that we rid of the backlog. But if you file a case today and you are being told we are dealing with 2016, 2018 matters, then it's a problem.
I want us to go to something else, and this relates to the United Nations Sustainable Development Goals. And I'm sure you are aware about it, and I want you to focus on goal number 8 of the SDG, particularly where we have equal pay for work of equal value, and also making sure that employment and decent work for all in safe and secure working environment. How does your code ensure that that particular goal is realized and protected as you continually do your work?
The decent work agenda developed by the United Nations has been mainstreamed in our legal and cooperative frameworks in Kenya already. The core conventions which guide the principles of equal pay or equal work have also been mainstreamed in our laws.
Very good.
So if you look at various provisions of our law, they are there. It's a question of implementation, and for the court is to make sure those provisions, and especially the constitutional edict under Article 41, which especially touches on that issue, fair remuneration for all. Equal, it's just a matter of implementation.
Okay, you are at liberty to answer this question, Honorable Judge, and it's not anywhere within my write-up here. Earlier on, you talked about making sure that you protect, promote work, particularly as relates to women, girls, and the rest. Do the boys child have any place in your...
I'm very, very concerned, I know, like every Kenyan, with the boy child, appreciating how much we love our mothers and sisters, and so much effort.
I've not heard anybody talk about fathers.
Nobody talks about them. Really, I know this is a real concern now, even for the mothers. They are becoming now more concerned about their boys than we are. And I believe there will be very, sooner than later, we are going to have both our mothers and fathers working together to further the protection of the boy child, because he's really under siege.
Very good. Chair, just before I end up, devolution, which is very, very key in our governance structure. If you get this position of Chief Justice at the head of judiciary, and you happen to be invited by the Council of Governors, who are very concerned about the level of justice in their various counties, what 2 things would you address them as far as judiciary is concerned? If the Council of Governors pays you an appointment as the Chief Justice, They are out there in the 47 counties across the country. Will you share with us two things you would be able to let them know that we need to do to enhance access to justice in our counties? Two things.
The first issue, which actually is in my imagined blueprint as the next Chief Justice, is upscaling all the ICT pilots.
ICT?
Pilots. And I want to use a devolved model. The only way to upscale our pilots, which are this automating court processes, which is working now, I believe, at the Supreme Court and Appeal Court. That, especially that particular aspect of freeing the hand of the judge from writing, which, Commissioner, in my 8 years as a judge in the little kingdom of Swaziland, I never did, because the courts were already automated as early as 19, and our judges, and they sit there.
I want you to focus to the audience. Your audience is the Council of Governors.
So I will deal with how the Council of Governors will help us to develop, first of all, our Mahakama centers.
Mahakama centers? These are court centers, I presume, eh?
Absolutely,
Okay.
because already we have done so well with the other, what are they called? The centers of service delivery in every county. I would want to focus specifically on the issue of land allocation in the counties where we don't have land to build our courts. Because we have an edict, a constitutional edict to have a high court station in every county. So that will be an issue for me.
Land allocation.
Land allocation.
Next one.
And facilitation, cooperation in the upscaling of ICT solutions in our courts in every county.
Okay.
I believe they have a very good experience, because within a few months, all the county assemblies had Hansard systems implemented within months.
Finally, Madam Chair, Judge, I alone talked about issues of internal controls. I'm aware that you have the Judiciary Leadership Advisory Council. And this morning, I did try to look at the membership of that council and the functions of that council. Are you familiar with that council internally? The Judiciary Leadership Advisory Council?
I sat with it.
You sat on it?
All the time I was the principal judge.
Up to 2017?
Yes, up to 2017, yes.
Then, if you sat in that council, which one will take its internal cabinet? The one that is supposed to address all these issues you have talked about, discipline, and you actually said about Honorable Judge Wajala's committee that was taking the issues regarding judges. One gets a little concerned. Is that council, is that internal mechanism working? And if so, how effective? If not, why?
It is an advisory organ. Advisory.
Advisory to who?
The members of that committee, comprising of the heads of courts, the principal judge, the presidents of the courts, the principal judges, the deputy chief justice. We advise the chief justice. Everybody comes there to advise the chief justice, who sits in all other organs of the judiciary, especially this JSC, so that when he comes as the chair of JSC, he has inside information as he comes to sit with you. So we would have thematic papers. I would, for example, as a principal judge of the Employment and Labor come up with a paper, table it there for purposes of advice and feedback on the concerns.
So how often does that council meet? Because from what you have said, Honorable Judge, this morning, a lot of things this morning that you said, one gets the impression either this council is dormant, the council is not working.
I am aware that it has sat since I left in 2017. I am aware from reliable information from my principal judge that they have only met once.
Okay. Thank you, Chair. Thank you, Judge.
Thank you very much, Commissioner Gishohi. Now is the turn for Commissioner Koskei to ask a few questions.
Thank you, Chair. Good afternoon, Judge.
Good afternoon.
Yeah, I've been listening carefully since morning, and I realized that you reflected a lot on how judiciary should be run, what is obtaining on the ground, and the possible improvements that needs to be done. And I wanted to know from you, looking at judiciary as currently is, are there areas in your view that that you think can be, differently, can be run differently to enhance efficiency and effectiveness? And you can give us about 4 areas: 2 judicial side and 2 administrative.
Thank you very much.
And also why? Why are you?
Thank you
why
very
do you think
much.
that is what you want to do first? Yeah.
Okay. I believe in my already I've alluded to some of those areas. I have key concerns in the area of promotion of especially the staff and the magistrates.
Yes.
A framework which is known
So
and accessible.
So
of
staff matters you need to sort out.
Yes, and in the same vein, I had talked about within the staff the discipline, transparency of it.
Yes.
And I'm very, very concerned about the fact that the judge's hand has never been freed in a medium income economy like ours. When I know, as a matter of fact, poorer countries, I don't want to name them, in the southern part of Africa, freed the hand of their judges in the 90s. And I don't know why, and that will be, in fact, if I can achieve that, if I can automate all the courts within my 5 years, and I know I'll be so passionate about that, I think access to justice will be almost resolved, because it's a key issue.
Yes.
Yeah, I know we have started because of COVID, we have started engaging in the e-filing and the CTSs and court management systems and all that, and the pilots we have. So already the pilots must be rolled out, and our budget should, from the exchequer and mobilized, should really focus on freeing the hand of the judge, making the registries user-friendly by, the filing.
Automation, the
automation
third one?
of the payment systems, and of course, in transcription. This will completely hasten the period within which cases are resolved.
But very well. The third one, the third area that you may want to look at it differently?
We say motivation is a key element so I want more transparency in the way various motivation is done to the staff within the judiciary. I already talked about why is it that one officer has got 2 state commendations within a period of a few years and all the other staff don't have. Why do we know for sure why this various motivation initiatives, what is the transparency of it?
Yes.
I think is what is important, so that we all work together as a team, because we are in it together, not for ourselves, but for the people of Kenya.
Yes, so any other area that you think you'll move in quickly and handle it differently? You've talked about staff matters, you want to see it to be done it differently, you say information.
I believe...
what else?
Sorry, I believe once our key mandate is to shorten that case turnover rate.
Yes.
Once I focus on that, I will have touched so many other areas.
Backlog? Okay.
Yeah, backlog is in there. It will be tackled once we deal with the issue of hastening the processes by enhancing our ICT capacity and yeah.
Yes. Thank you. My second question is a bit outside what we've been discussing, and I think it was slightly touched by Commissioner Gishori. Ease of doing business. I hope you have had ease of doing business, where the executive is playing their role in terms of infrastructure, in terms of, trying to shorten the processes, like even registration of business entities, trying to reduce the number of licenses, etc. And legislature also is trying to amend laws to align it so that business in this country is a lot easier to establish and to run. And there have been some bit of concern that judiciary, being a very critical player in ensuring, in any country, in ensuring that they create confidence to the investors, is not playing its role in Kenya as is expected. Cases take too long, disputes are done in a manner that investors don't understand, especially foreigners. Now, as you are coming in as a new Chief Justice, having in mind that Chief Justice Emeritus Mutunga laid the foundation and made things more easier, Chief Justice Maraga also came and fiercely defended the independence of judiciary. Kenyans are saying they want now a Chief Justice who has some kind of business philosophy, business-minded Chief Justice to help the country to attract investment and to help the country to create wealth. Do you fit in that description? And if so, first of all, you need to let us know if you are aware of the challenges that the business community is facing in this country in terms of investment and many other things surrounding investment, and what solutions are you going to offer?
Thank you. As I worked at the Federation of Kenya Employers, and actually most of the time as the deputy CEO of that organization in acting capacity, because I was head of legal, I interacted with the spectrum of all the investors in this country and employers, and the key concern was certainty of decisions made, especially in the labor courts,
Yes.
The commercial division, especially, because those are the... And specific on some key issues like procurement, which result in a lot of delays and nullification of tenders. Specific key areas of concern to investors and any investor. And again, as a Chief Justice, being the embodiment of the judiciary, interacting with your college as your peers, and in our colloquia, and in our education program, it is just a matter of really, you cannot have a policy of certainty of decisions made by judges other than educating them and on the need as we educate each other in our colloquia, and the Chief Justice taking a leading role, so that when we are seized of matters to do with major procurement, individual contracts, commercial contracts, that we prioritize those matters, and we utilize and precedents, especially because the Court of Appeal is key in this, because the different judges of the High Court will have different decisions. The harmony in commercial decision must come from the Court of Appeal. Actually, and I know they appreciate that more than any other court, because that is where commercial disputes should end, actually. So if there is certainty in the decisions of the Court of Appeal, there will be every investor will know, once I bring my money, this is what the Kenya law says. This is what the judges of the final court on matters commercial and matters labor are saying. So that is a key issue, and which I think I should be able to give direction as the embodiment. Really, you cannot have edicts to the judges. These are peers with independence, which I value and respect so much. Then the engagements. The judiciary has really opened up to the investors and business community, and that we have, I believe, a lot of initiatives in the commercial division and other already to ask them decision making, because that's the other thing. Delayed resolution of commercial disputes. Labor is a key consideration for an investor and for a Kenyan who is doing business, because that really impacts on their bottom line and ability to do business. So in fact, so two issues is certainty of judgment and the turnaround period. Those will be my area of priority in that respect, understanding that growth of a country will depend on the levels of investment, local and foreign.
Yeah, on the same, they say that commercial division has lost its identity, its focus that was created to do, and lands court is another nightmare. Now everything stops at lands court. What are you going to do specifically with lands court, commercial division, and I think you have mentioned possible solutions to your court now. Those two, they say that nothing moves. If you go today to lands court, you will be given a mention or a hearing in 2023 or 2022, and an investor has come in with billions, he can't do anything. And many investors are moved out of the country because they are frustrated. There is no prioritization. Which to the investors, it looks like judiciary is not aligned to the government vision, to the government prioritization list of how do we bring investors that will come and create jobs for our people. So what action are you going to do? What is this that you can come and do as Chief Justice Nduma Nderu to enable this problem to be alleviated or even clearly moved from bringing problems to society?
It's a fact that land is a key factor of investment and business anywhere in the world, and more so in Africa and in Kenya. I'm aware that land disputes are multivarious and so complex, starting from the lowest level of the magistracy to the Land and Environment Court. I know that it is now a specialized court. Before, land disputes were open to the entire High Court, and therefore we narrowed these disputes to be handled by a specialized court, which I think now has 34 judges? If I'm not sure about that figure, but and ideally every county, every High Court station should have an ELC judge. And I think because land disputes are close to the people, and we in my view, that in the access to justice, a lot of consideration should be given to having enough, at least a land court in every county. I know the magistrates are doing their part, but there are those which must go to the High Court. I know the number of judges in that court is too small. It's too small, and should be a concern of any Chief Justice. It will be my concern because the jurisdiction is limited and no other judge can deal with the matters. So that, and of course, the rapid initiatives of disposal of cases, which we have been doing collectively, should be more focused in that area also.
Thank you. Thank you for your answer. My final question is on your involvement in community service. I've seen that you are currently the chairman of a secondary school in your home county. You also participate actively in your parish. You are once even a captain of Swaziland Golf Club, and you even pay school fees to many needy children. I wanted to understand your philosophy on public involvement and practice, giving your time to the community. What is your philosophy? What is it? I don't want to direct you to your philosophy. And as you're answering that, how do you anticipate your personal philosophy on the same? Would it be like, would it translate into some kind of character of your administration in judiciary when you become CJ?
Yeah, there's a lot of inequality in Kenya rising out of history, our history, and of course our stage in economic development. And so we interact with so many levels of inequity and poverty across. And I'm very, very grounded, first of all, from my formative years in my community, and that is why I have consistently been involved in focusing on education of the child, because I know within our communities where we come from, education of one child and frees not just that family, sometimes frees an entire clan, an entire community. That is my philosophy. And that passion of giving, I think, should be reflected in terms of community service within the judiciary. It should actually be mainstreamed within the judiciary, and I would work with all the stakeholders in the judiciary to mainstream programs which uplift the people we serve, our communities.
Yes, thank you, Judge. Thank you, Chair.
Thank you very much, Commissioner Koskei. Before I call upon Commissioner Orwade, because after she talks, then the interview will be over. Judge, you talked very passionately about the independence of judges. And as a commission, we agree with you fully because, as you know, we have 4 judges in the commission. And we all feel, we all agree with that independence. But just a little bit of clarification, Your Honor. For example, we receive about 150 complaints against judges each year. So you can imagine for the last 10 years, we have received like 1,500. And for the last 10 years, we have only forwarded 8 of these cases to the president to form the tribunal. And out of those 8, only 3 have been removed. So the 99.5, we don't follow. And how we do it, Your Honor, when these cases come to us, we look at them, and a lot of them are merit-based, and a lot of them are decisional. So we actually don't follow, and even judges never get to know. However, there are some that we feel, let the judge come and explain. And then out of those people, out of those judges who come and explain, again, many of them, we agree with them. Out of that, there are few, Your Honor, that we feel, even though they have responded, let them come and explain further to the committee. So there's that, process that we follow. But eventually, a lot of the very, very few judges, of course, as you know, as I've given you, end up going to the tribunal. So because we also feel that the members of the public, Your Honor, and the lawyers who complain, we also have a duty to listen to them and then follow up. And my question, even as I explain this, Your Honor, don't you think the independence also can be abused? Is it possible for this independence to be abused? And my second part of the question, isn't it true that independence also comes with accountability? So that just because the judges, honorable judges, have got independence, we make sure that some of them, whether 1 or 2 or very few, are not hiding behind that independence to avoid accountability. So it's both a clarification and a question, Your Honor, before we go to the final set of questions. Thank you.
Yes. So I really appreciate that question, Madam Chair. And it is true that accountability is a constitutional edict for every state officer, a public officer. It's a command. Inasmuch also the independence of the judiciary, especially the decisional and independence of a judge, is paramount. And that is born out of history of injustice and oppression, and where the judiciary systems have been used and mainstreamed actually to oppress the people. And that is, and when you read that history, you know that in as much as you want to deal with those matters which must be dealt with, especially to do with misconduct of a judicial officer, the a very difficult balancing act must be there to protect especially the decisional independence of a judge. The moment that goes, we will all close our offices and go home. It will be chaos. And we often take that for granted. We are informed by history so that we never fall into the same pitfalls of the past. And it's true, I really appreciate the role of this commission in ensuring that judges and magistrates are accountable to the people of Kenya who gave this authority unto us. All I am saying is, as a Chief Justice, working with you commissioners, I want to make sure that those processes do not hurt the judicial independence of judges, because that is so central to the administration of justice. And the people well educated would never want to touch it, because they will be the victims and defeat them without the judiciary and judges protecting them, and magistrates and all judicial officers.
We agree with you, Judge, and I agree with you. It's a question of protecting that independence, but also making sure there's accountability. And I think that's a balance we need to also kind of respect. So thank you very much, Judge. Now I would request Commissioner Evelyn Orwade to ask her questions.
Thank you very much, Chair. Good afternoon, Judge.
Good afternoon.
My first question deals with the death penalty. Death penalty. The death penalty has been dealt with and discussed in our apex courts in several perspectives. 3 cases come to mind. We have the Ngotho Mutiso versus Republic case, Mwaura versus Republic case, then the famous Muruatet, which you already spoke about. Now, Judge, I just need you to differentiate between the holdings in these 3 cases concerning the death penalty, and tell me your views, your personal views concerning those holdings.
I will try to admit that other than Muruatetu case, given my area of focus, right now in the judiciary, I have not interacted directly with those 2 other decisions, but if you were to give me the ratio in those decisions, then I'll be able to give you a very good answer on what I think.
Okay. In the Ngotho Mutiso case, the ratio concerns the constitutionality of the mandatory nature of the death sentence, and the finding was that the Constitution does not restrict discretion on the subject of the death sentence, specifically in respect to murder trials. In the Mwaura case, the question was whether the death sentence was unconstitutional by virtue of it being or offending against the freedom from torture, inhuman and cruel punishments. And the Muruatetu, of course, you said you know.
Yeah. First of all, I really appreciate the Supreme Court decision and direction in allowing judicial officers to have discretion based on the facts of each case on issue of death sentence. Of course, the Supreme Court left that death sentence as a lawful remedy because I believe that is still our constitutional edict, that death penalty was not out, still a lawful sentence in our constitution. I think central to all that, and to which is applicable in my own view to any registration which hinders the discretion of a judicial officer by giving a minimum sentences, is that we should have none, because the function of a judicial officer is to balance each case on its own facts and merit, so that we do not see, for example, a lot of injustice, which I think we've read about so much, about the young boys languishing in the cells all over for longer times than they would have, and the judges been given discretion to consider their specific circumstances in each case. So that is my view, without going to the details of those cases, because I haven't interacted much with them.
And what about the death penalty itself? That is about the discretion. What about the death penalty?
Sorry, I've just said that our constitution did not outlaw that, and I believe that is why the Supreme Court did not go that way. And but the law evolves all the time, depending on the context of each nation. And I'm sure this is not the last we've seen of that in our developmental law and justice in our country.
Okay, thank you, Judge. Under what circumstances can a public officer maintain an account outside Kenya?
You have to be specifically be allowed to do so by a parliament registration. If there is no enactment which allows you to do that, then I think you're prohibited by the Constitution itself to do that as a state officer.
Do we have an enactment that allows as we speak?
I'm not aware of one.
You're not aware of it?
I'm not aware of it.
We actually do. The Leadership and Integrity Act. It gives the circumstances under which
yes, I have seen
you can maintain an account.
Seen that. I have seen that.
Okay,
yes.
Thank you, Judge.
Yeah.
Can a Chief Justice hold dual citizenship?
A state officer should not.
A Chief Justice?
As a person holding a state office, I believe, should not have dual citizenship. A state officer.
I'm specific to a Chief Justice.
No.
Not at all?
Okay, judges, I know, can have dual citizenship. I think also maybe the Chief Justice, I must admit, I'm not sure, but I think judges may have dual citizenship in terms of the law.
The Chief Justice is a judge, my lord.
I would want to reflect on that, on the responsibility of a Chief Justice, but I think as a judge, then he should have, because judges may do that. Yeah.
Okay, thank you, Judge. I must admit I was getting quite excited when you were giving your exposition on the issues that plague especially members in this institution, in the lower cadres. As you said, you lifted from the employee or staff satisfaction survey. You hinted at what you propose to do concerning some of those issues, one being discipline, which you said you are looking to developing a framework that will help the process to be fair and just, which basically to me, in my ear, sounded like a complaints handling mechanism or policy. And then you also talked about promotion. Promotion is also an issue, especially for judicial officers, because you know, we all, I think about 95% of judicial officers aspire to ascend to the superior courts. The superior courts are like canon for them. But before they get to that canon, there are several Red Seas they have to cross in the form of promotions. Now the challenge here is there is no indication when this Red Sea will open. And that is the problem, like you aptly put it, with our promotions. So I want to hear from you, Judge, and for your prospective subjects, if you become Chief Justice, for their benefit, what would you do, or what do you propose to do to arrest or address this problem?
Of promotion?
Yes, my lord, it actually affects not only the magistracies and the caddies, even the judicial staff. It's a very sore issue.
I am very, very aware of it. Not now, just for purposes of this interview, but I've interacted with that as a principal judge immediately as I was serving. I interact with this because, as I said, I'm a very interactive person, so I speak to judicial officers at every level, freely and openly, and so I am aware. For example, what happened to those who had applied last time round to be promoted from magistracy to...
Actually, Judge, I'm talking about promotion within the ranks of the magistracy, the caddies, and judicial staff.
Yes, I'll come back to that, but I wanted also to tell you that I'm aware that even as a chief magistrate and tried to become judges, I was aware, and because I interacted with them, that it appeared as if there was a minimum age, number of years you must have served to be even shortlisted, although it is not part of an open framework. And I believe so much in transparency and based on documented and developed through interactive processes, so that if we are having problems of career progression from the first level of magistrates to the next one and to the next one, and same with the other cadre in the not in the judicial service. What we need, I know we have a big human resource manual. I'm also, if you look at my CV, I also trained in the South African Institute of Management on matters human resource. So I'm very aware of difficulties of implementing policy which is hidden in big books and not translated into small, workable documents accessible to everybody, so that they know this is a criteria from moving from a resident magistrate to the principal magistrate. And these are the considerations, and they must be taken into account. And this is becomes a policy document that must be developed as a working document for implementation purposes. That is the only way you will ensure that there is fairness in the movement of judicial officers at every level. It's transparency in and developing accountable small frameworks extracted from the big book, so that any JSC dealing with promotions is alive to the fact that everybody knows what the criteria is, and that they have been commanded by, or they have commanded themselves, because of course the document eventually will belong to JSC, to follow this line, and sometimes also, that also, once you have transparency, you deal also with perception. There's a reality and this perception. But in this case, I know there's a lot of reality. But transparency also kills perception. and acceptance of whatever decision JSC makes in promotions. So that's the key.
Thank you very much, Judge, for that response. My next question I've lifted from what you said earlier. You said a court order has to be obeyed, whether the person agrees with it or not, because to do otherwise would lead to anarchy. Now I want to ask you, if a party is vehemently opposed to an order that has been served on him because he totally doesn't agree with that order, what is his remedy?
He must implement it and seek redress.
In what way, my lord?
Seek. He will make an application to have the order set aside. If he does so immediately, then the matter will be reconsidered, because there's always room for review of orders of court. But if you do not move an application for review, or you don't file an appeal, then you must obey the court order. And even if you move for review, or you file an appeal, and you apply for a stay pending the hearing, and you don't get it from the court, you must obey that order.
Thank you very much, Judge. Now, another concern I want to raise with you concerns the membership in your court and the other specialized court. There's a general feeling that they are not put at par with the members of the High Court. I'm talking about the courts of equal status. And when it comes to nomination, which is almost more or less the same thing as promotion for magistrates, to the Court of Appeal, they feel like they're disadvantaged. What would you do to address those concerns if you become Chief Justice?
Thank you very much for reminding me of that. I should have even talked about it earlier. And those of us who sat with me at the JLAC know that I was very passionate about that, and I actually brought concept papers. I was asked to, because of my persistence, that let there be equality, because the Constitution tells us we have established courts of equal status, and therefore let us treat them equally in all matters across the board. And I remember during after the last elections in 2017, and JLAC was faced with the issue of swearing of governors, and the view there was that an ELC and an ELRC judge is not qualified to swear a governor. And when I persisted and I asked to be shown which part of the Constitution says that, which law outlaws us from doing that, of course I lost by vote, having been told to present a paper on it, and because of my persistence in there, that we are not being treated equally. Having sworn governors in 2013, myself, I swore the governor of Marsabit and Justice Mutunga. I went to swear that time the entire assembly, the speaker and everybody else, plus the governor. And then all of a sudden we were not qualified to swear judges. Then I also presented concept paper there about judges of ELC, with the support of Okongo, the PJ for ELC, being appointed as presiding judges. I think it's a matter I followed up persistently, and I was not successful, because up to now, indeed, no ELC judge or ELC judge is a presiding judge. And we witnessed also judges who had earlier on from ELC elevated to presiding judge being demoted, and judges who had just been appointed being elevated to be their bosses at those respective stations. We saw that happen, and you can only talk because you're in an advisory. While I was the principal judge, we are there to advise the Chief Justice, and I did so passionately that that has not borne fruit. But in one way, it did bear fruit. SRC then gazetted allowances for presiding judges, which include ELC and ELRC judges. Again, after that happened from SRC, I took up the matter again with the current principal judge of my court, and especially in our specific colloquial, annual conference with the Chief Justice, and we have been not successful to date. It's an area of dissatisfaction and a feeling of unequal treatment, I must say. Thank you for reminding me. And it's an area I would want to tackle with JSC, as soon as I'm Chief Justice, if that be the case.
Thank you, Judge. Now, you are aware that after receiving applications from all the candidates, JSC had to take them through a vetting process. We sought information from members of the public out there, and we got information. We got complaints from various quarters. In keeping with what the chair has just told you, we got quite a bit in respect to you. Some of them touching on your decisional independence. We shared them with you, you responded. You have your response, we are going to consider them. But there's one particular one I want to raise with you, Judge. Without necessarily mentioning the parties, but I'm sure it's a matter that was brought to your attention because I have seen your response. In this particular matter, the complainant was engaged in a legal tussle with his employer. And the long and short of his complaint was that at some point, he was brought before a board on disciplinary hearing, I suppose, on accusations which in his view were based on vendetta from his employer. The matter was heard. The board absolved him. Subsequent to that, the employer was not happy, and the employer changed the membership of that board, called him for a second hearing, which, of course, he refused to subject himself to, because in his view, he had already been absolved the first time. So, of course, they were engaged in a legal tussle before your court, and at some point, not necessarily handled by you from the beginning, but at some point, the complainant came before you seeking orders to suspend the order terminating his services and his pay. And you granted him those orders, ex parte. Subsequent to that, it appears at some point the employer stopped paying him, and he came back before you about 4 months or 5 months later and applied for the employer to be held in contempt. Now, instead of doing what he expected you to do, to hold his employers in contempt for disobeying your order for that period, what you did is you dismissed his application because he failed to disclose certain material facts when he came before you ex parte. Now, you are within your discretion to make that decision, but I'll tell you why this concerned me a bit. We already agree that if a party is aggrieved with a court order, it's upon him to approach the courts for necessary action and to do that promptly. It is not upon a party to decide that I agree with this order, or this order is unfounded and I will not obey it. From the narration of events, I also read the judgment that you made. It seems to me that the employer in this particular case, between the period you made the order ex parte to the point the complainant applied for him to be held in contempt, he was in contempt. But in your decision, you focused only on the failure of the complainant to disclose material facts, but you said absolutely nothing about the conduct of the employer in disobeying your order, which was actually the subject of the application, in disobeying your order for the entire period until the complainant came before you. This is a concern because we are all aware it's in the public domain that disobedience of court orders is a very sore issue in the administration of justice. And the concern is, as Chief Justice, should we have concerns that you may not be up to the task when it comes to enforcement of court orders?
I think I remember that one, and I appreciate, and I responded to it in writing. The issue there is what was the nature of non-disclosure to me. I remember as I was handling that matter, is during COVID period. I'm operating from home in Nairobi. They are in Kisumu. And so, when I gave the ex parte judgment, ex parte orders, it's on a basis of an online application. I don't have the file in my house. And there goes the need for an applicant in those circumstances to give me all the circumstances of the case before I issue the order. And what was the nature of that information? That the same matter was before Justice Morino Nyango, who had considered it and issued a ruling on it. So when the matter came for inter-parties hearing, that was disclosed to me, and actually an opportunity to see the ruling of my sister judge, which if it had been disclosed to me, I would never have issued that injunction. That is why I dismissed that application on the basis of non-disclosure. That was such a material non-disclosure that my decision was in direct conflict with a ruling already done by my sister judge. And therefore, I exercised my decision-making reasonably after considering the circumstances. And the kind of non-disclosure which was not made to me.
My Lord, this non-disclosure you discovered in the application for contempt by the complainant.
Yes.
You were not moved by the employer. Is that correct?
No. If you look at my ruling, I consider the submissions by the employer. They're the ones who disclosed this to me.
In the application for contempt?
Yes.
Thank you, my Lord.
Yes.
Okay, moving on to the application documents that you filed. I don't know if you have your files with you, your papers with you, the applications that you filed.
The application.
If you look at the advertisement that was put in the papers, the applicants were required to download Form 2, JSC 2A for public officers or JSC 2 for other applicants. This is in keeping with the statutory provisions in the first schedule, Regulation 4, that requires you to fill a prescribed form in making your application. Did you fill that form, my Lord?
Yes, I did. This is a form I filled, I downloaded and filled in the...
My Lord, I saw what you downloaded. It is not from JSC 2A. That is the online application. It is not the prescribed form. If you look at the advertisement, I'm sure you have a copy of it in your bundle of documents.
Yes,
the advertisement required you to fill that online application and, amongst other documents, download from 2A, JSC 2A, fill it and upload it along with the application, the online application, as well as submit one hard copy of Form JSC 2A, which form is supposed to be filled in your own handwriting. You did not comply with that, my Lord.
The form I had allowed me to type in that part. And so this is a form I brought, and where there was space, that there is space for typing, I did my typing, and I believed and I said that I filled the correct form. If indeed this particular form is not the correct one, I do not know until this point, but I believe this one, the form I downloaded and filled, presented me with opportunities to deal with the application appropriately, including filling the part which was supposed to be done about my own information, which I duly typed.
Okay, my Lord, if you look at the form you submitted, the way it is, because that is how it has been presented to the Commission, in Form JSC 2A, or even Form 2, at the end of it, there's a declaration where the applicant is attesting to the truthfulness of all the information he has given in his own hand in Form 2, JSC 2A.
Yes.
Do you have that in your form?
Yes, I have, and I duly signed.
Is there a declaration on that form?
Yes, at the last page, and there's a signature in PDF.
The one I have, my Lord, sorry, the one I have does not have that declaration. Maybe we'll get to look at the copy that you have.
It is there. Maybe there's a...
Could you read the declaration, my Lord? The declaration you have in that form.
Oh, the last part says final declaration, and then the declaration date, which I put, and the signature in PDF. That's the last.
Just read the declaration, my Lord.
It would appear that
there's none.
This is just in the printing, but it was there.
That's my point exactly, my Lord.
It's just in the printing, but the declaration is there, duly signed and filled by myself, and dated the 8th of February 2021.
Okay, moving on to the next issue. Did you apply for clearance from the EACC?
Yes, I
Ethics
did.
and Anti-Corruption Commission?
Yes, I did, and I have presented the originals today.
Okay, thank you. Is your wife a public servant?
She is not working thanks to COVID. She's never been a public servant.
In your wealth declaration, you are required to give a schedule of your income, your assets, and your liabilities. Why do you think we ask you to give all those details? Why not just ask you, tell us what you own? Why do we ask you to give your income, your assets, and your liabilities?
I did that. It's a part for the income, all those three.
My Lord, I'm not asking what you did. I'm just asking you why, the rationale, why we are asking for those three components, not just for you to declare your wealth and tell us I own blah, 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 blah.
It's an issue of integrity.
Yes. Why?
Yes. It's in terms of the Constitution and the code of conduct that we feel, and we've been filling those forms. It's not the first time we are doing that, and that is why we have filled for the past many years.
Yes, my lord. What do you think we do with that information? Your income, your assets, your liabilities. Clearly stated in different paragraphs. What do we do with that information?
I'm not sure what you do with it, but it's supposed to reflect my correct status of income and assets.
Okay, let me ask you this, my lord. If in your schedule of assets, because we fill these forms periodically, right? In your schedule of assets, we see a property that is worth as an amount X, for example.
Yeah.
There is no corresponding income of amount X, and there's no corresponding liability in terms of a loan of amount X. What are we supposed to make of that?
It reflects value of the, you have to look at when the property was acquired, because I don't believe there's any property there in my declaration which was acquired yesterday. Most of them were acquired even before I became a judge, and during only one or two which was acquired when I was a judge. What changes is the value, the market value of the property.
I'm not talking about the market value. I'm
Because
talking about...
if you see a property worth this amount of money, and in the previous declaration it was this amount of money, it reflects, because we are giving estimates, it reflects the market value of that property at that particular point in time, and even development which has happened in that land. Using my income, I am developing my properties, which I acquired before I became a judge, and they appreciate in value all the time. And what is reflected there is my estimated value of my properties in terms of the market rates.
What if it's a new property, my lord?
There's no new property.
I'm not asking about your case.
Yes.
What if it's a new property? Should that be a cause for concern?
If it is a new property, yes, there will be a cause of concern which does not apply to me. I do not have any new property because most of my assets there were acquired mainly from my work outside the judiciary, and the assets acquired when I am a member of the judiciary, acquired through the mortgage, judiciary mortgage, okay, and
if I may ask, my lord, which property was acquired through the judiciary mortgage?
That is my home in Lavington. That was acquired through judiciary mortgage, which I have also reflected that the amount of loan outstanding.
So you stand by your word that there is no new property in your declaration?
For the period covered, the period of 3 years?
The last 3 declarations.
I have disposed of, if you look at them, there were properties which were there, and they are no longer there because they have been disposed of. And there is only one piece of land which was acquired, but I have also disposed other properties. If you look at carefully, I have, you will see that properties which were there at this time, they are no longer there, and there is, I think, only one new property, just one, but the values, the change in values are just a matter of market rate, not because the properties have been there.
So you say you've acquired some property out of disposing others?
Yes, you look, yes. And
is that reflected in your declaration?
I believe you have, when you look at my statements, bank statements, which are from 2017, you will be able to see disposal of property. Okay.
Is that reflected in your wealth declaration?
It is in the statements. In the declaration, you will see.
My lord, what I would expect is this. Maybe I can just break it down for you so that you understand my concern.
Yes.
What I would expect is this. If I have 3 properties, property A, B, and C, I dispose of B and C and subsequently acquire X. In my last declaration, I had A, B, and C. What I would expect is, in my subsequent declaration, B and C would not appear, but there would be income showing on the space where I'm supposed to indicate income, that I got income from disposing property B and C, and subsequently acquired property X. And that's why I'm asking, is that reflected in your wealth declaration?
If you read that in conjunction with my bank statements, it's very well taken care of.
Okay, let's move on. Let's move on, my lord. There's a company, I'm assuming it's a limited liability concern, called Cited. In your wealth declaration, you have mentioned it severally, but my concern is you have not disclosed what your relationship with Cited is, and if you are one of the owners, in what ratio your shares are, and what it is worth.
That company is not operation. It's there, but it's not. Since COVID, is not operational. Since 2006, it's a business by my wife, HR consultancy, which she has done since 2006, and submitted accounts to KRA, financial statements for all that period, and I have indicated that in my declaration. We don't have much space to say other than indicating our personal emoluments, and I indicated that the accounts of that company have been filed since 2006 with KRA.
What is your relationship with Cited? Do you have shares in Cited?
Just a family. What is it called? Is it called nominal one? For that time, because you could not register with as a single director.
So it's a company owned by your wife?
By my wife, and she has consistently filed accounts, and that is why we got clearance, I believe, from KRA, because she has been compliant throughout. But now there was a small family concern.
Okay, thank you.
She's been running it herself, and now it is not operational because its area of focus could not go on due to the international, the closure of international boundaries, because our focus was outside the country. She was training and personnel mainly from without Kenya, and that's why she could no longer operate.
Okay, thank you. And are you a Sharia SACCO member?
Yes, I am, and I provided statements to that. I don't know whether you received my bundle of statements.
I saw your bank statements.
There is also a bundle of statements from Sharia SACCO. Which one?
You also did not declare indicate the dividends amongst the income that you get, the SACCO dividends.
Yes, they are all in those statements, because all along, I must say that we have been submitting these wealth declarations, not for purposes of interviews. And those forms have no space telling you indication that you're supposed to make attachments. We have never been asked to attach any document to those declarations. In fact, I'm sure almost all the candidates were surprised by the requirement that we attach bank statement, because it was not apparent at all in the advertisement. We've never done it before. All what we do the estimates of our income, and we declare our assets, and we don't attach any documents.
Actually, my lord, maybe to make it clear,
but
because
you
now
will see the attachments of my bank accounts clearly show my little contribution on a monthly basis to Sharia SACCO. They show that whatever dividends they pay, they also show the loans I have the loan I have taken there, and they show my contributions to date. And so, for purposes of accountability and transparency, you will see everything in that statement from Sharia SACCO.
Okay, thank you, my Lord, for submitting your statement. I saw your statements this morning, but I just want to make one thing clear. We did not ask for bank statements. I know this must have come from the questions that the previous candidates have been asked. What I've been asking about is declaration of your bank balances. If you have an account, you have money, that under Section 2 of the Leadership and Integrity Act, in that description, money is one of the assets that you have. So that if you have 2 million in your account, all you're required to say is that I have an account at this bank and the balance there is 2 million, because that is part of your asset, not necessarily the bank statements. And at the same time, about the forms, you are always at liberty to attach an extra form or an extra paper detailing your assets if the space there is not sufficient. Just to set the record straight, my Lord. Otherwise, thank you very, very much for your patience. I'm done. All the best.
Thank you. Thank you. Thank you.
Commissioners and Your Honor, this brings us to the end of this interview. And
local clarification.
yes, Honorable DCJ.
Thank you. My Lord, there is something you said that I think we should not leave hanging. And you said that the manner in which the Supreme Court has handled, you are calling them two, but the Supreme Court has actually handled 3 presidential election petitions, has left uncertainty. That's what my Lord said.
Has left?
Uncertainty.
Oh, uncertainty. The two. We were focusing on two of them.
Then my Lord has also expressed dissatisfaction, I think that's what I got, about the Weber case. So those are 2 concerns there. This is the question. What in law can or should be done about those judgments? Now, when I asked you the question in the beginning, I said, you give us either a critique or a criticism. I do not know what it is my Lord gave us. Was it a critique or was it criticism? But whichever it was, because both are okay,
Yes.
My Lord feels that we have convoluted issues rather than shown the way to go in both the election cases and in the Weber case. And so I ask, this also is a learning process, or is it not? So I ask, my Lord, then what are we to do? What do we do with those judgments?
Maybe convoluted.
Within the law, not what we feel. Within the law,
Yes.
what do we do? That's the first part. The second part, when my brother, the Law Society representative, was talking to you, there's something there you said about the big picture, right? And I want to know whether that big picture is part of our jurisprudence and how it relates to constitutional interpretation theories. Those 2 clarifications, my Lord.
On the first one, maybe convoluted is a strong word. I did not use that. But especially on the Law Society case, its impact on the ground is very, very real. There's a lot of disaffection in the way, especially from the court users.
My Lord, that I had, that
Yes.
we had. And
preparing to
and
answer you.
incidentally,
Yes.
we began there.
Oh, I see.
During my practice, we went to the director first before we went to any court those days. So, of course, you answer the question in the manner you best think is the way to satisfy us. But for me and my constituency, it is that critique or criticism, the judgments stand. They are the judgments of the apex court, the final court in the land here. And so I'm asking, in the law, because we can only act within the law, what are we to do?
Okay. Actually, there has been a lot of robust discussion of that amongst ourselves in ELRC court, because we also realized we are handling the issues differently. And we also got a long memorandum from the magistrates raising the concern that in the court users committee, they have a representative saying that they are totally confused. They don't know what to do, and there's a lot of disparity in how the different officers are dealing with it. And so we said, the opinion was, let the matter go slowly up to the Supreme Court. It will be dealt with. And in my view, I strongly think that may not even happen, because that depends on the court users to move. But this case, we have a particular court user, the Law Society, which, with its capacity of legal minds, probably would want to engage the Supreme Court once again on that particular remedy for clarification, so that then you can also now reconsider the matter quickly and give an edict to the rest of the courts. That would be a much quicker way, but of course it depends on the court user. From where we sit at the judiciary, we can only watch as decisions are made and they come, hoping that one day they will reach you again, and which I think is not a satisfactory way of dealing with our court users. So that's one. The other one was,
my Lord, it was the use of the word, the bigger picture. And so I'm asking whether that is an emerging form of jurisprudence, and whether how have we been interpreting the Constitution? Are there not enough theories on how to interpret the Constitution, and is the bigger picture part of that jurisprudence?
I do not recall myself using that particular word in that context of interpreting the Constitution, because I said very clearly that the Constitution has got commands in various articles telling us how we should interpret it and what values and principles we should use. I think that was my bottom line, but I don't think if I used the word bigger picture was in that context of interpreting the Constitution.
Thank you, my Lord. As I said, it doesn't matter whether it's a critique or a criticism.
Well, it was a critique. I think we are bound by the decisions of the Supreme Court.
Actually, that's the word I was looking for.
And you have seen that in some of my judgments I have submitted. I have a lot of deference to your decisions of that court, but I think
it is criticism.
A critique is good at this kind of forum.
It is criticism that would make that court grow, or any court for that matter.
Yes.
But it has to be criticism that is within some parameters, isn't it?
Yeah, within the law.
Yes. I thank you, my brother. I thank you.
Chair, just to Chair.
Yes, we need to bring this to an end, Commissioner, but go ahead.
Yeah. I mean, just arising from what the Honorable DCJ was asking, like you mentioned about that case of Weber, where a good decision, but so many other complications arising.
Yes.
You know, the big picture in that sense, that when the decision is being made,
yeah, I think so.
You as the CJ ensuring that you look beyond the decision and the implications.
Oh,
Same thing also with Muruateto, where a good decision, but again, all the courts interpreting differently, and coming up with different, parameters, so causing more complications.
Yes.
So I don't know that, so big picture in that sense, are you able to expound what kind of a CJ would you be to ensure that even as you're making the decision, you're able to foresee that in the implementation, it doesn't end up causing more problems, even as you're coming up with the constitutional interpretation and principles?
Well, as I said, that as the Supreme Court, even as the Chief Justice, we are only but a college of judges, with me being the first among equals and the DCJ being the second, and we cannot just use the best of our persuasion to make sure to sensitize ourselves on the need to issue effective court orders, especially if matters are likely to affect a very big constituency like is happening now. The Supreme Court itself has addressed itself very much on the effectiveness of court orders, and in particular in Mitubel case, where they felt very strongly that the orders of the High Court were not effective and they were general and they'd set them aside. So I'm actually speaking from the mouths of the Supreme Court judges on the need to have effective final orders which are capable of implementation. So I think that is, if the big picture was in that context, then I think that was the view of the Supreme Court, especially very strongly expressed in the Mitubel case. That is what I was talking about. We need to have effective orders capable of implementation without causing hardship. Yeah.
Thank you very much, Honorable Judge. We will stop there. We want to thank you, Judge, for your, number one, applying for this job and also availing yourself. And also talking very passionately, Judge, about what you believe in, and also being very candid and very honest. We want to thank you for that. And on behalf of the commissioners, we wish you well. But before you go, do you have anything you'd want to tell the commission, Judge?
Ni vema na haki ni mshukuru sana sana kwa vile mmenitendea haki na mmeendesha hii hafla kwa njia inayofaa, kwa makini, hekima na utulivu mwingi. Kwa kufanya hivyo nafaa nimpe sifa, manake kazi yenu inapatia Kenya yetu sifa, napatia na mnapata sifa katika ulimwengu wote na mbele ya Mwenyezi Mungu. Sifa nayo inastahili mpate, na kwa hivyo mimi nawashukuru sana, nampongeza na wahisi muendelee vile vile mpaka mtakapopata jaji mkuu atakayetumikia Kenya kulingana na katiba yetu ya Kenya. Mungu awabariki na waongoze. Asanteni sana.
Thank you very much, Your Honor. So we come to the end of this session. Your Honor will be escorted out by Honorable Anne Amadi. Thank you.